Court does call the case of the People versus Julius Clay.
People. Erica Julia Kern, on behalf of Julius Clay, Julius, can you state your name for the record?
Thank you. All right.
Welcome in, because this case wastes no time throwing us straight into the legal deep end. A preliminary examination may sound procedural, but it's actually one of the most critical moments in a criminal case. This is where the judge decides whether there's enough evidence to move the case forward to trial. No jury yet, just raw testimony, credibility checks, and early legal strategy unfolding in real time. We already hear complications, key witnesses unavailable, scheduling conflicts, and attorneys navigating how to proceed without essential testimony. That's important because missing witnesses can dramatically shift leverage between prosecution and defense. The prosecution wants momentum. The defense may want time to challenge evidence or strategy. And notice how the judge carefully balances fairness with efficiency, offering options to continue now or adjourn so everything can be heard together. These early decisions shape everything that follows. Here's the hook. We're about to see questions of entry into a home, alleged assault, child custody tensions, and identification disputes, all emotionally charged and legally complex. So as we dive in, ask yourself, is this a misunderstanding spiraling out of control, or are we about to uncover something far more serious? Stay sharp, because the first witness is about to take the stand, and the story is just getting started.
Taking time for preliminary examination of the people. Ready to proceed.
Your Honor, we are ready to proceed. We're ready to begin. We will not be able to conclude today, unfortunately, because one of the deputies that has some of our information is not available, but we will be able to proceed today with the civilian witness requesting an adjournment conclusion of our testimony. I was, after the state was set, Ms. Hughes did send me an email subsequent to that stating that she had learned that Deputy Luke would not be available today, that she believed that she would need him in order to conclude the exam. I did not have a particular response for that. I understand that that can occur. So I wasn't sure who the people were proceeding with for today, but we do intend to move forward.
All right, so you don't have any objection to start. I mean, I would grant the adjournment.
I understand that, Your Honor. So I don't have a response to the fact that the people would do that.
Okay, did you want to start today? I mean, I realize it's sometimes a matter of preference. It may be what the defendant wishes to have happen. Did you want to begin today, or did you want me to? My next date, well, when do we know when the deputy's available?
Detective Luke will be back next week, Your Honor.
So, just so that you know, I have time available. I could hear it 1 week from today, and it would all be together, or I can break it apart. It's up. But if I adjourn it out, so that you also know, if I adjourn it out, it will be adjourned to June 11th.
May we approach, Your Honor?
This always happens with you, Julian. Yes. No, you always just want to talk to me. I know. Come on. But I'll come up and see Miss Lundy. I don't. We had a bench conference in this case. I got everything. All right. You may proceed. You all set? Okay, call your first witness.
You call Alan Duva.
Sir, please come forward and be sworn.
Before you take a seat, raise your right hand, please. You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Have a seat.
You need to, yeah, he does.
Need you to state and spell your first and last name for the record.
Alan Ruba, ALANE, is in David, U, B is in Victor, A.
Now we move into witness testimony, and this is where courtroom narratives begin forming. The first witness often sets the emotional tone, but legally, it's about establishing facts. Who was present, what happened, and why police became involved. Watch how the prosecutor carefully builds a foundation, confirming address, date, and circumstances before touching the actual incident. That's intentional. Courts need testimony structured step by step so later details aren't thrown out for lack of foundation. You can already sense discomfort and hesitation from the witness. That matters. Jurors and judges evaluate credibility not just on words, but demeanor. Nervous pauses, uncertainty, and fragmented answers can weaken or complicate testimony. And notice how the questions avoid hearsay, focusing only on what the witness personally saw or experienced. That keeps testimony legally admissible. The tension here isn't explosive yet, but it's simmering. Two men allegedly enter a home uninvited, a child is involved, and things escalate quickly. This moment is about to pivot from background setup into confrontation details. And what comes next will determine whether this incident looks like protection, aggression, or something legally ambiguous.
All right, you may inquire.
Thank you, Your Honor. Mr. Duva, can you hear me okay? Excellent.
Was that a yes, sir? Okay, thank you.
Mr. Duva, where do you live? What lot number? Is that in Washtenaw County, state of Michigan? Were you living there on February 7th, 2024? Did something happen that day that it caused the police to show up to your home?
Yes. Well, the morning, so the knock at the door, and I answered it, and two men came in. Kim, the girl was the drug trailer, said that they were trying to chase the child.
Sustained.
So let's break that down a little bit. You said there was a knock at the door and two men came in. How did they come in?
It wasn't.
This is where things get serious. Entry into a home without permission immediately raises legal red flags. In U.S. law, a home has some of the strongest protections. Unauthorized entry can potentially support charges ranging from trespass to home invasion, depending on circumstances and intent. Notice the key questions. Did you invite them in? Did they touch you? Did they force entry? These distinctions matter enormously in court. The difference between walking in through an open door versus forcing entry can change the severity of charges. The emotional stakes climb fast when children are involved. Now, we're not just talking about entry, but potentially custody conflict or attempted removal of a child. Prosecutors will want to show fear or harm. Defense attorneys may argue misunderstanding or lawful purpose. Let's pause here with a question for you. If someone entered your home believing they were protecting a child, would that change how you view the situation? Or does entering without permission cross a line no matter what? These are the moral and legal gray areas courts wrestle with. And testimony is only getting more complicated from here.
I opened the screen door and they entered and went directly into the front bedroom, which is right next to the front door.
Did you invite them to come inside?
Not really.
Did you say anything to them?
No.
Did they make physical contact with your body when they came inside? What happened when they were already inside of your home?
Jim said that they were trying to take the child.
So
Sustained.
one of the things about these questions I'm going to ask you, we're not going to talk about anything that anybody except the men said or you said, okay? So what happened when they came inside? They went to the bedroom? Who was staying in that bedroom?
Kim,
What's Kim's last name?
trying to think of it.
How do you know Kim?
She was the daughter of
The daughter of one of your girlfriends? About how old do you think Kim is? Was there anyone else staying in the house? Any children?
yes,
Say it again for me, please.
her son,
About how old is her son?
around 2.
So when the men went into the bedroom, without telling me what somebody said, what happened next?
Walked into the doorway and Julius Clay stood in front of me.
Objection, Your Honor. There's a total lack of foundation for that statement.
Sustained.
So there was somebody that stood in front of you. Do you see that person in the courtroom today?
I think so. The person that I'm looking at.
Your Honor, may the people request that the defendant remove his mask to see if it's the same person that the witness saw that day?
Response.
To be frank with you, I find this,
And here comes one of the most delicate moments in any courtroom: identification. This is huge. If a witness misidentifies someone, an entire case can collapse. Defense counsel immediately objects, arguing that the witness may already know the defendant's name or has been influenced by outside conversations. That raises concerns about suggestive identification, where circumstances unintentionally push a witness toward identifying the person sitting at the defense table. Remember, in court, the defendant usually sits in a visible, obvious spot. That alone can bias identification. Courts are extremely cautious here because wrongful identification has historically been a major cause of wrongful convictions. Judge Simpson steps in carefully, yet trying to untangle whether the witness remembers faces independently or relies on conversations afterward. This moment is less about drama and more about protecting fairness. Because once a witness says, "That's him," it can carry enormous weight, even if uncertainty exists. And now, the judge pauses proceedings to avoid contaminating the process further. Smart move legally, but the tension in this courtroom just jumps significantly.
I guess I have to, he could not identify any other person. And it is highly suggested to have Mr. Clay sitting at this table, and somebody must have informed him of Mr. Clay's name, because that was never part of any of these reports. And so I have great concerns about whether or not he's about to make a misidentification.
Do we have to go through my?
What? 1 second, sir. 1 second. Thank you.
What did you say? Do we have to go through your phone?
Yes, there's a number of conversations about this case.
Okay, hold on, sir. Pardon?
And there's things that brought up.
Okay, but I think that complicates things even further. But for the purposes of looking at the identification, I don't want to know what was said, but who brought up the name to you? As you sit here today, without those conversations or whatever else was said, as you sit here today, do you recall what the individuals entering the home looked like?
Here, the judge drills into something critical: independent memory. Can the witness recall what happened based solely on what they personally saw, not what they later discussed or read? Human memory is fragile, Studies show recollections change after conversations, media exposure, or repeated retellings. That's why courts test whether identification comes from actual observation or later influence. The witness struggles to separate original memory from later information. That uncertainty is gold for defense attorneys because reasonable doubt thrives on unreliable recollection. The judge's careful questioning protects both sides, ensuring testimony remains fair without prematurely dismissing it. And this leads to a broader issue. Eyewitness testimony feels powerful, but legally, it can be one of the weakest forms of evidence if not supported by physical proof or consistent accounts. At this point, the case feels less clear-cut than it did minutes ago. Instead of a straightforward incident, we now have blurred memories and disputed identities. And that uncertainty could shape everything going forward.
Someone, yeah.
Okay. And do you believe that as you sit here today, based upon seeing them presumably on that day, that you could tell whether or not somebody was there?
Yes.
Is that absent the conversations that you had?
Yes.
So the individuals that entered your home, how do you know their name? If you do.
I know the first one of them was named Ryan. I can't.
Okay, but did you,
And the other one is Julie.
sir, you can stay right there. Let's take him back. Counsel, I want to see him.
Yes, sir.
Court is standing in recess.
All rise. The 14th District Court, County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson presiding.
You may be seated.
If we could have him brought out, yeah.
You don't want him brought out?
Well, the whole issue, if Mr. Duva is going to be excused for the moment so that we can change over. Can we call the case, Your Honor? Oh, I'm sorry.
Court recalls the case of People versus Clay.
Ashley Londy for the people.
Erica, we have to explain why I have to stay back for the moment so we can sort through this issue.
All right, go ahead. What would you like?
Obviously, we had a right to hear concerns regarding potential for identification or misidentification of this witness. But I would ask at this time is that this witness be excused at this moment. I know that the exam is going to be adjourned to another date anyway, and I need to evaluate the testimony that was just received as well as next step for the defense regarding how I might handle that legally. And so in order to protect the record from what might be perceived as future taint, I would just ask Mr. Clay.
Understood. Right.
This is a strategic timeout. Defense counsel asked to excuse the witness so they can evaluate how to respond legally. That's not stalling. It's defense lawyering at its best. Once testimony enters the record, it can't easily be undone. So attorneys pause proceedings to protect their clients' rights, especially when identification issues arise. Judge Simpson also references earlier testimony involving a co-defendant, hinting there are deeper complexities we haven't fully heard yet. Judges rarely speak this cautiously unless they sense potential evidentiary problems. In simple terms, the court wants to avoid mistakes that could later cause appeals or mistrials. This moment might feel procedural, but legally, it's massive. Decisions made here could determine whether evidence is allowed later or challenged successfully. So here's something to think about. Should courts move quickly to keep justice efficient or slow down to guarantee accuracy even if cases drag on? Justice delayed can be frustrating, but justice rushed can be dangerous. The courtroom now shifts gears as another witness prepares to testify.
All right, and I understand that. And just so that the record is clear, without going into the specifics, this court had heard the examination of the co-defendant. There are some concerns that the court has and should allow counsel for the defendant to explore regarding the purported, or what I suspect will be an in-court identification of the defendant in light of that testimony. I'll leave it there so that I don't say too much, but we'll do that. I will then excuse this witness.
Thank you, Your Honor. And as the people indicated in chambers, it is our intent to recall this person when this
Yes.
case is adjourned to on June 11th.
Yes. Thank you, sir. You may sit down. All right, he has now left the courtroom. We can bring the defendant out. We're on the record in the People versus Clay matter. The record should reflect that Mr. Clay is now present in the courtroom.
Thank you. I just may have one.
All right, let me call your next witness.
Thank you. The people called DeAndre Burton.
Sir, please come forward to be sworn.
Will you take a seat, raise your right hand? You solemnly swear to affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I did.
Have a seat. State, spell your first and last name for the record, please.
First name is Kanye, E-R-E, last name Burton, B-U-R-T-O-N.
You may inquire.
Thank you. Sir, how are you employed?
Work for Washington Sheriff's Office.
In what capacity?
I work for the Police Services and the Deputy Sheriff.
How long have you been a deputy sheriff with the Washtenaw County Sheriff's Department?
2 years now.
Were you so employed on or about February 7th, 2024?
Yes,
What shift were you working that day?
in that shift.
And were you assigned to a specific area or what?
Yes, I was assigned to Flint Township Road Stroke.
Did you respond to an address on Julie Drive that night? Do you remember that address? Is that in Ypsilanti, Michigan, Washtenaw County, state of Michigan?
Yes.
What happened when you arrived at that scene?
The patient was pretty, she was crying, she was hysterical. She stated that her son was just taken by her child's mother.
How many people were at that address when you responded there?
A total of 3.
How many males, how many females?
1 male, 2 females.
Did you happen to make contact with the male at that location?
No, my partner did.
Did you observe that male?
Yes, I did.
Did you later come to know his name?
Yes.
What was it?
Alan?
Alan? Did you observe any injuries on Alan?
Yes, he had an injury to his head.
Now we hear from law enforcement, and this testimony usually carries strong credibility weight. Deputy Burton describes arriving at a chaotic scene, emotional distress, multiple individuals present, and physical injury observed. Police testimony often helps prosecutors establish what officers saw firsthand, rather than relying solely on civilian accounts. Injuries documented by officers support claims that violence or physical confrontation occurred. However, notice something important. The deputy did not personally interact with the male suspect at the scene. That gap could matter. Defense attorneys often highlight when officers rely on secondary information rather than direct contact. Also, emotional states at scenes can influence perceptions. Someone crying hysterically doesn't automatically prove wrongdoing occurred, but it strongly shapes how incidents are perceived. The prosecution's strategy here seems clear. Build a consistent narrative through independent sources. Civilian witness plus police observation. But consistency isn't certainty, and in criminal cases, the burden is proof beyond reasonable doubt. We're approaching the procedural end of today's hearing, but emotionally and legally, things are far from settled.
Do you recall where?
Like in the middle of the head.
You're using your hand and you're sort of circling around the back crown of your head. Is that correct? Can you describe the injury that you saw?
It was a large amount.
Did you make contact with any suspects at that location?
No.
One moment, please.
Yes.
Pass the witness.
All right.
I have no questions for this witness.
All right. Thank you, Deputy. You may step down.
Thank you. Your Honor, I believe the date that court said was perhaps June 11th.
Yes. So we will stop this examination at this point. Preliminary examination will be adjourned. Court's continuation to June 11th.
The court adjourns, meaning this preliminary examination will continue later. Adjournments can feel anticlimactic, but they're common, especially when testimony isn't finished or evidence still needs review. Bond continuing means the defendant remains free under existing conditions while the case proceeds. That decision balances public safety with the presumption of innocence. But watch what happens next, because courtroom decorum becomes the focus. Sometimes tension built throughout proceedings spills over when participants feel frustrated or misunderstood. And here's a question for viewers. Do you think defendants sometimes hurt their own case by reacting emotionally in court? Or is it understandable when someone feels their freedom is at stake? Courtrooms demand strict behavior standards. An emotional outburst can influence how judges perceive cooperation and respect. We're about to see Judge Simpson address conduct directly, and that moment may say as much about courtroom reality as any testimony we've heard so far.
2024 at 11 a.m.
11 a.m. Thank you, Your Honor.
Yes, before me. Thank you. Bond will continue at this time.
Thank you, Your Honor.
Did you explain to him why?
I'm sorry, Your Honor.
Mr. Clay, bring him back out here. Where'd she go? That way. Mr. Clay, don't act that way in my courtroom.
I'm sorry.
Ever. I realize that you want this to proceed at a certain pace. Rest assured, part of the reason that the conference was taken in my chambers with your attorney was she was seeking to make sure that all of your rights were protected. You acting like that, quite frankly, and I hate putting it this way, but acting a fool leaving my courtroom does not help that circumstance. She will explain to you everything that's going on and why. So am I understood that you will not act that way ever again here?
Yes, sir.
Judge Simpson ends the session with a firm reminder. Courtroom behavior matters. Judges expect respect and order because emotions already run high in criminal cases. When defendants react emotionally or storm out, it can damage how they're perceived, even if their frustration feels justified. Looking at the bigger picture, today's hearing showed several key issues. Disputed entry into a home, alleged physical injury, unclear identification, and procedural caution from both sides. Nothing has been proven yet, but enough questions remain for the case to continue. The judge's ruling to adjourn allows attorneys to prepare carefully, ensuring future testimony is fair and legally sound. That's essential because decisions made at preliminary examinations can shape trial outcomes. The broader takeaway? Courtrooms are not just about facts. They're about credibility, procedure, and how stories are legally constructed piece by piece. This case is far from over, and future hearings will determine whether evidence ultimately supports criminal charges or reveals a different story entirely. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.